Hi guys, this is the Business Guy, and today we're going to talk about protecting your assets like the rich, the 5 rules they don't want you to know. And be sure to stick around until the end, because rule number 5 is the most powerful strategy the wealthy use to protect millions of dollars. And I'm talking about a legal firewall that even the most aggressive lawsuit can't penetrate. So let's dive in, and if you like content that helps you protect and grow your wealth, do me a favor, like this video, subscribe if you haven't, and tap the bell so you don't miss out on future strategies. The rich don't wait for lightning to strike before they buy insurance. They don't wait for a lawsuit to hit before they protect their assets, and neither should you. So number one mistake I see, people come to me after they've already been served, and they say, "Business Guy, I just got hit with a lawsuit. Can you protect my assets now?" Look, I've been doing this for 34 years. I've set up more Cook Islands trusts than any firm in the world, and I can tell you, asset protection works best if you act before the legal storm. I mean, you wouldn't buy fire insurance after your house has already burned down, right? Same thing here. In the legal world, there's something called fraudulent conveyance, and that's when you move assets after you know a claim is coming. Judges don't like that. Now, we can protect your assets after you've been sued, but even if you're doing everything legally, you're now fighting uphill. So the key thing is protect your assets as early in the process as possible. So if you've got wealth, real estate, investments, cash, crypto, a business, and no protection plan, the clock is ticking. The wealthy know this, and that's why they move early before the problem arises. So that was rule number 1, start before there's a problem. Now, rule number 2 is separate ownership from control. And here's a secret most attorneys never teach. You don't have to own something to control it. And that's how the rich play the game. They separate ownership, the legal title to something, from control, the ability to make decisions and benefit from it. So let me give you an example. Let's say that you own a rental property in your personal name. A tenant slips and falls, they sue you. Now all of your assets are at risk. But what if instead of owning that property directly, you owned it by a land trust, and the beneficial interest in that trust was held by an LLC? You're simply the manager of the LLC. You've just made yourself a ghost because on paper you don't own the property. You control the entity that controls the trust that owns the property. That's layers of legal protection. So let me be clear, control is everything. We've set up structures for clients where they manage a portfolio worth $20 million, real estate, brokerage accounts, businesses, but legally they own nothing. Their legal name is nowhere on the public records, and that's not just asset protection, that's financial invisibility. Rule number 3, use the right legal entity for the job. Now, some people think an LLC is an LLC. It's not true. Just like a screwdriver isn't the same as a power drill, legal tools have specific purposes. So let's go ahead and break this down with a few examples. Land trusts, great for real estate anonymity. They hold title, but they don't protect against liability. It's a smokescreen. They're good, but they're good for their chosen purpose. LLCs, limited liability companies, they protect you from inside lawsuits, like somebody slipping on your rental property, and outside lawsuits, somebody suing you personally. Corporations, useful for operating businesses. An S corporation helps reduce self-employment taxes. A C corporation may be better for reinvesting profits and unlocking 1202 capital gains exemptions. Irrevocable trusts for long-term wealth protection, estate tax reduction, and shielding assets from lawsuits or creditors. So here's where people mess up. They use the wrong tool for the job. In fact, I've seen people use living trusts thinking because it has the word trust in it, it'll protect them from a lawsuit. Spoiler alert, it won't. A living trust is for estate planning, passing assets on to your heirs, and not for asset protection. Another common mistake is setting up an LLC in their home state like California, New York, or Florida, and thinking they're protected. Now, most of these states offer weak charging order protection. That's when you're sued personally. They can take the LLC away from you. That's why we prefer Nevada LLCs, or especially Wyoming LLCs. These states have strong laws that keep creditors from seizing your interest, even if it's a single member LLC. Plus, Wyoming gives you privacy, no public record of who owns it. We also add nominee managers to keep your name out of the public records. So use the right entity in the right jurisdiction for the right job. That's how the rich stay safe. Rule number 4, maintain your legal formalities. Now here's the boring one, but ignore it and everything you've built can come crashing down. I'm talking about corporate formalities. When you set up an LLC or a corporation, it's a legal person, and just like a person, it needs to keep good records. Maintain your annual filings, pay renewal fees, keep separate bank accounts, so don't commingle personal and business money. You wouldn't pay your electrical bill with your LLC bank account. You take the bank account with your LLC owns, put that in your personal checking account, just pay yourself, and then pay the money for your personal bills like your electrical bill out of your personal checking account. Document major decisions. File taxes properly. So why does this matter? Because if you don't treat your entity like a separate legal being, neither will the courts. And that's where we hear the phrase that no business owner wants to hear, piercing the corporate veil. That's when the judge says, you ignore the rules, so now your personal assets are fair game. The rich don't play that game. They respect the rules because they know the penalties for sloppiness are steep. In fact, at our firm, Asset Protection Planners, we coach clients on how to maintain their legal shields because a Ferrari is useless if you never change the oil. And a legal entity is worthless if you don't respect the formalities. Okay, that brings us to rule number 5. Here's the big one. Use offshore trusts with offshore LLCs and Swiss bank accounts. All right, now we're at the final and most powerful rule. And if you've made it this far, you're about to learn the single best asset protection strategy in the world. We call it the Fortress strategy. And here's how it works. We set up a Cook Islands trust, in certain situations a Belize or Nevis trust, and inside that trust we place a Cook Islands LLC or the equivalent LLC in Nevis or Belize. Now here's the key. You're the manager of that LLC when the waters are calm. You can move money, make investments, go online, do stock trades and so on, even open a bank account. But when the legal threat strikes, we have licensed bonded trustees in the Cook Islands, our licensed law firm, our licensed trustee company, and they can step in. They firewall the trust. Now, a U.S. court can scream all at once. It has no jurisdiction offshore, so where do we recommend the LLC holds the money? A Swiss bank account. Why? Because Switzerland has some of the strongest privacy and stability laws in the world. They're not going to roll over for a U.S. judgment. They've been protecting global wealth since the 1700s, and they're extremely selective about clients. Now, you may be thinking, is this legal? Yes, 100% legal. These structures are fully compliant when set up correctly. There's no tax evasion. Everything is disclosed properly. We're not hiding. You're protecting with the law, not against it. So let's go ahead and recap this Fortress plan. The Cook Islands Trust, a jurisdiction that doesn't recognize U.S. court rulings, has a 2-year statute of limitation on fraudulent transfers. Now, the assets are protected right away. An opponent has a short period of time to challenge the transfer, which they'll probably lose anyway. We've never seen anybody win that lawsuit when they've challenged the owner or the beneficiary or the settler of a Cook Islands trust. And that's a lawsuit they'll lose, by the way, because we've never seen somebody penetrate a Cook Islands trust that we set up. Cook Islands LLCs inside the trust, you manage it until the lawsuit strikes. Swiss bank accounts, stability, privacy, and protection from U.S. creditors. So this is the gold standard, and I say this with confidence because we've set up more Cook Islands trusts than any firm in the world. We've helped doctors, real estate investors, entrepreneurs, and high net worth families legally bulletproof their wealth with this strategy. Some have protected $2 million, others 20 million or more. We've had billionaire clients. We've had people with $500,000 in liquid assets. So if you have over 500 grand in liquid assets or just a few pieces of real estate and you want real security, not just hope and prayer, then this strategy could really change your life. You can go ahead and go to assetprotectionplanners.com to learn more or get a free consultation with my team. Here's a real case study, the plastic surgeon and the frivolous lawsuit. Let me show you a quick real world example. A plastic surgeon in California, let's call him Dr. K. He had a thriving practice, and one day a patient sues him, claiming a malpractice. The claim is shaky at best, but the plaintiff's attorney is aggressive and well-funded. So Dr. K had protected his assets in advance. He had a Cook Islands trust that we set up with a Cook Islands LLC inside. The LLC held a Swiss bank account with nearly $4 million. And when the plaintiff tried to freeze his accounts, the judge found nothing. On paper, Dr. K didn't own the assets. Legally, the trust did, and the jurisdiction, it was offshore, untouchable. So the lawsuit dragged on, but the plaintiff's attorney ran out of steam. No assets to grab, no pressure point. They settled, and they settled for pennies. So that's power. That's not because Dr. K was lucky. It's because he was prepared. So here's some final thoughts. So there you have it. The 5 rules the rich use to protect their assets. So the key thing is start before there's a problem. Separate ownership from control. Use the right entity for the job. Maintain your legal formalities, and use offshore trusts with offshore LLCs and Swiss bank accounts for the most powerful protection. I've been in the asset protection world for 34 years. I've seen lawsuits, bankruptcies, the business partners that turned enemies, the divorces, the surprise judgments, and I've also seen the tremendous relief and peace of mind when a client hears the words, "They can't touch your assets, they're safe." So that's what we do, and that's what I love to do. So if you got wealth to protect, don't wait. Go to assetprotectionplanners.com or drop consult in the comments below. My team will reach out for a free, no obligation strategy session. And if you found this valuable, give it a like. It really helps out a lot. Subscribe to the channel if you haven't, and share it with somebody who really needs to hear it, because financial peace of mind, that's priceless.